So I'm never been sure whether Jefferson was right that the government that governs less governs best, but it is certainly true that the moderator who moderates least moderates best. So I'm going to try to keep my role here to a traffic management minimum and give you guys as much opportunity to hear from the judges as possible. And I want to, all have agreed to dispense with opening statements and to make this as conversational as possible. And so I want to start, and let's start with our district judges here, with a kind of institutional assessment of the performance of the district bench in over the last 9 months. Let's just go down the line. My impression is that the district bench has been somewhere between excellent and spectacular. And I mean, obviously, there's a huge amount of variability. But you know, if you just take the recent case in the latest outrage in deporting people under egregiously inappropriate circumstances on quick notice, you had a pass-off from Judge Suknanan, who dealt with it in an emergency basis over a weekend, to Judge Kelly. And you would never know by a word that either of them spoke or wrote which was appointed by a Republican, which was appointed by a Democrat. I could give you 100 other examples of that. So my first question, and just let's start with Judge Grimm, do you agree that the district bench across the country has really shrouded itself in a certain amount of glory, and that it looks incredibly apolitical from very conservative appointees to very liberal appointees? They've kind of looked very similar in the handling of a lot of cases.
So from the perspective of a district judge, a retired district judge, what am I going to say? I'm disappointed. I think that the district courts have been spectacular. I think they have been the line in the sand. I can tell you from the work that I have done, the level of personal attacks and threats against them has been beyond anything that you could imagine. And I think if the American public actually heard some of those threats, that they would be appalled. And you would not know for a nanosecond from the actual rulings that the judge was appointed by either a Democratic or a Republican constituent or president. In addition, I think it is critical to say that an example of that is in my own court, where all of my colleagues were sued for the fact that they had an order that said that if emergency habeas corpus petitions were filed, oftentimes at midnight or on a weekend, that there had to be a 48-hour delay before the executive department could move them to another state and divest the court of jurisdiction. Similar to something that a lot of circuit courts have, because most of the immigration cases bypass the district courts and go straight to the courts of appeal. The judge who decided that case, Judge Cullen, was appointed during the first Trump administration. And in footnote 2 of his decision, he used examples of the type of vilification that has been directed towards the district courts. And these types of attacks have occurred in the last decade, but there's nothing comparable to the scale and the nature of these attacks that we've seen in the last 10 months. But he concluded that this was a purposeful engaging on behalf of the executive department to smear the judicial branch. And that was by someone appointed by a Republican president, the same president who's the president right now. So when you look at these decisions and you focus on the outcome, it has not mattered one bit. And there's always going to be some judge that might see it a little bit differently, but guess what? They show their work, and the appellate courts can take care of it if they disagree with it. But I think that the district courts of the United States have been magnificent.
Go for it.
I don't disagree, but I have to admit that I am surprised. Maybe it's a surprise about this administration, but I've also surprised at the court. I had the unpopular position when I left the bench of writing articles in which I described how the greatest pressure I felt as a judge was to, quote, duck, avoid, or evade, settle cases, encourage people to plead, just not make thunderous decisions. I generally didn't pay attention to that, but that was the pressure that I felt. So when Trump was reelected, I was worried. And what you have seen is district courts meet the moment in a way that I think is extraordinary for our country, I think extraordinary for the court. First, people grouse about the pacing of litigation. There are orders that have been issued at 1 a.m. There have been, the Supreme Court, we'll talk about the shadow docket, the Supreme Court issues emergency orders, 1 paragraph, 2 paragraphs, maybe 3 pages. These judges have issued 60, 100-page decisions in a matter of days, hold expedited hearings, hold expedited briefings. And it's not that they're doing so with respect to issues that are the ordinary the ordinary caseload of a district court. I mean, this is not ERISA cases. These are all novel cases. And also, this is an area in which the courts have usually not been active, namely deportation cases, namely tariff issues, as we talked about in the last panel. So they are not just meeting the moment in terms of what they're doing, but how they are doing it, and really offer a model, I think, we'll talk about this, to the Supreme Court about how one does emergency work, how one deals with it. One reason for the pattern you're seeing across the country is that if we step back, what the administration has been doing is literally unprecedented. So the distance between what they are doing and what they are trying to do and what the court has to resolve is enormous, and Congress has been among the missing. So the courts have dealt with issues they haven't been used to dealing with under circumstances which courts typically don't have to deal with, emergency orders in areas where they never had to address this before. So I'm astonished. The notion that Just Security has a litigation tracker that is, I think, up to almost hundreds and hundreds of cases suggests exactly what the pressure is on the courts. It is difficult. Right at this moment, the courts are not shut down, even though people, they're understaffed. Hearings are continuing. Jury trials are even continuing, even though jurors are not getting paid. And as Judge Grimm described, judges have been subject to a degree of threats that certainly I didn't experience when I was on the bench. And it's not just the threats from lunatics and from disgruntled, litigants. It is threats from legislators and threats from the president. And so that has an impact both on the bench. It has not been reflected in their decisions so far. In other words, that level of intimidation. But it's been reflected in their personal decisions. One judge I talked to had to move because the marshals reported that he couldn't protect them in the house he was living in. So they moved in order to address that.
So Judge Luttig, you have a slightly different perspective on this, being an appeals court judge, and you've spent many years hearing district judges congratulate themselves for the magnificence with which the way they handle things, only to find that they need to be reversed on X point or Y. So I'm interested in your sense of whether what we've just heard is a district court-centric view of the world, and actually from an appellate point of view, the district courts always look a little bit less wonderful than they do to themselves.
Well, having now read the extensive briefing and heard the arguments from the courts below, I affirm for the reasons stated by the district courts below. But I'm not on the Supreme Court, nor would I want to be today. I am going to explain my opinion that I just rendered.
Touche.
Because I understand my legitimacy is bound up with my opinions and my reasoned explanations. No, Ben and the audience, the lower federal courts, both federal district and United States Courts of Appeals, have honored their oaths to the Constitution over the past 10 months. And in so doing, they have brought further honor to the lower federal bench at a time, at the most important moment in all of American history, when the nation needs the federal judiciary more than it has ever needed it and will ever need it again. To the judge and to the court, the federal judiciary, the lower federal courts have honored their oath, and they will continue to honor their oath.
So I just want to foot stomp a point that Judge Gertner made, that, you know, some of these cases are remarkably dense and complicated. You know, the administration has sought to dismantle entire federal agencies and fire huge numbers of people. The question of, can you do that in bulk, or do you have to litigate that on a bespoke individual employee basis, is a question that we've just never confronted before, because no administration has ever looked at the, say, Department of blank and said, no, we don't really think we should have this anymore. There's a judge on the DC bench who had literally been in office for, you know, like a month and a half when some of these cases started landing, Judge Ali. You know, these are, and this is a major impoundment case. Some of these cases, former Judge Grimm's former colleague, Paul Assini, is on the district court in Maryland, has had, you know, the Abrego Garcia case. These are cases of just immense difficulty, and by the way, and we'll get to this, the government is lying in a bunch of them, which, you know, is not something that you normally expect to have to deal with. DOJ counsel who are simply acting in bad faith. Judge Luttig, I want to, let's raise the level of scrutiny, and let's look at the appeals courts, the mid-level appeals courts, not the Supreme Court yet. This seems to me a more complicated picture. There's a lot of wonderful work product going on in the courts of appeals, but you definitely see more tribalism than you're seeing at the district courts. And there's definitely some auditioning for the Supreme Court going on among certain of your Court of Appeals, not the Fourth Circuit colleagues, but colleagues formerly on the, or currently on Courts of Appeals. How do you assess the institutional work product of the Courts of Appeals?
So, Ben, I think that I would say the same thing for the appellate courts as I did for the lower federal district courts. They, too, have risen to this moment in history. Of course, the appellate courts have a different role and different function. And for purposes of our conversation today, we can just understand that it's up to the federal courts of appeals to bring to the fore every single argument for and against the particular action by President Trump in this instance. And the courts of appeals have done that also famously well, in my view. Now, to Ben's suggestion that there's been some tribalism, that's fair to say, but it would also be fair to say that where you've seen that, quote, tribalism, I can tell you that those members of that tribe are staking out the long-held positions on these issues of the conservative legal movement through time. With this postscript, it's been said that I was a fairly conservative Court of Appeals judge, and I guess I was, and I still am. The Atlantic asked me to do an article about the first 100 days of Donald Trump's administration, and I did. They let me title the article. In the article, which I titled "The End of the Rule of Law in America," I chronicled and analyzed 12 or 14 of what I characterize as President Trump's signature initiatives during his first 100 days in office, and I concluded with reasoning and explanation, to the extent one can do that in an article as opposed to an opinion, that every single initiative was either palpably unconstitutional or otherwise in plain violation of the laws of the United States. In this instance, I don't get any credit for that. You know, a high schooler could have written the same article that I wrote. And I'm only being facetious in part. So demonstrably clear was the illegality of every one of them. Most of them on their face, as we lawyers say. For instance, executive orders against the law firms and individual lawyers and individual American citizens by the President of the United States of America. Those were the most corrupt of what he did. But you go to his two most signature initiatives, tariffs and the deportations. There's not been a president in 250 years who would have ever thought to do what Donald Trump did. Why? Because every president of the United States would understand that he, as president, in these times, has no authority whatsoever to impose tariffs, let alone the sweeping tariffs that he did. As to the his snatching off the streets of America American residents and deporting them to foreign lands to place them in the most squalid prisons in the world without, we say without notice. Hell, without notice, you know, an unidentified van pulls up, unidentified officials of Donald Trump's administration go up to these people and they take them away and they deport them to foreign lands. Talk about un-American, but think of this. The first one made its way to the Supreme Court of the United States. And thankfully, the Supreme Court said no. Quote, facilitate the return of Abrigo Garcia to the United States immediately. Within a week, Donald Trump was sitting in the Oval Office with the dictator from Venezuela telling the Supreme Court of the United States and the rest of the world, quote, Abrigo Garcia will never come back to the United States of America. Donald Trump defied the Supreme Court, and he'll do it over and over and over again during the next 3 years.
Judge Gertner, Judge Grimm, what do you make of the institutional performance of the mid-level appellate court?
I think your question about tribalism is true. I mean, for the most part, they have affirmed what the district courts are doing. There have been exceptions. There have been exceptions. The problem here is that what the district courts have been doing, when the first round of litigation happened, which were, emergency orders on a very scattershot record, judges would write opinions, that was one thing. But now we have a second phase, and the second phase are findings of fact, conclusions of law, hearings, factual findings. And the question then is, what does both the appellate courts and the Supreme Court ultimately do when a judge says, I've read everything, all the documents, I looked at the witness, I saw him to be credible, I make findings of X, Y, Z. Typically, that's not the end of the analysis, but certainly there's a presumption that unless the judge abused his or her discretion, that would stand. We're beginning to see, most lately in the Ninth Circuit decision, the Court of Appeals judges that are second-guessing the factual findings that district court judges have made, which is not usual and may be a response to maybe what you've described as tribalism. It may be that. But for the most part, the courts of appeals have not been overturning the district courts. Sometimes we don't even know because, as was a Judge Jackson wrote, that this administration has the Supreme Court on speed dial. So there has actually not been the usual kind of articulation of issues at the district court level, then at the Court of Appeals, and then percolating up to the Supreme Court. So I think it is a mixed record, although more good than bad.
I agree. I think that that in the main, the appellate courts have done a fine job. Obviously, as Judge Luttig said, they have a different role in the district court. I agree with Judge Gertner that it will be interesting to see what happens with factual findings. The notion that whether there's an emergency and if you have a judge that says there is no factual basis to support the contention that these conditions existed, which are the purported justification for the action, that's the kind of thing that ordinarily would get great deference. We've seen that appellate courts and the Supreme Court have been a little bit more willing to do appellate fact-finding in a way that they have really not done that in the past, so we'll see what happens as they move up forward. But I will tell you that the Fourth Circuit, Judge Wilkinson's decision when he upheld Judge Zinni's and commented about in the face of some very aggressive and blameworthy language used by the Department of Justice, that this was a hard-working district judge who was trying to get it right and following the directives of the United States Supreme Court, that habeas corpus was the proper way to deal with these kinds of cases. But Judge Wilkinson could have taken a harsh and divisive tone and in an elegant opinion that is a model for everybody to look at. He talked about how the President of the United States is deserving of respect, but that there's a bilateral obligation to have respect for the courts, and that in the absence of that kind of comity is a recipe for lawlessness. It was an elegant decision that was done by someone who's a reminder that not only what we say matters, but how we say it is important. That level of awareness, I hope that we continue to see that as these cases move higher, and that's something we'll have to keep an eye on. But I agree that I think that the appellate courts have thus far, with certain individual cases such as have been decided, have done a fine job.
Ben, let me just add that for the audience that the arguments that are being made in all the courts, frankly, by the Department of Justice attorneys under Pam Bondi are contemptuous, not just of the Constitution and the rule of law, but contemptuous of the federal courts, and even, if not especially, contemptuous of the individual judges that are hearing the cases. Not only has this never happened in all of American history, not one argument like the arguments that these people are making to the federal courts has ever been made in American history, dripping with the contempt that these arguments are.
I want to add to that too. It's also it's not just an issue of the arguments they're making. They're lying. They are misrepresenting things. One of the things I thought when the debate, after Trump was elected and when the political debate made it into the courts, that one of the things we know about courts is a level of civility, and that lawyers, true to their oath, will not lie, will not misrepresent, will not say they do X and do Y. What is most shocking of all in a time when we're always shocked is that that's not true. That's not true with respect to the Department of Justice lawyers. They will say X, they will do Y, and recent whistleblower accounts suggest that they are openly and brazenly misrepresenting to the court. The system fractures when that happens. The other thing, I think it was in Just Security, that also had a piece on
You
the
keep
presumption.
citing Just Security.
I'm sorry.
Me. I mean,
I'm sorry. No, I know.
Hurts my feelings.
I know. Well, we'll work on that. Where the presumption of regularity has gone. I wrote a piece before Trump was inaugurated about the kinds of statements that were being made by proposed candidates for the DOJ about who they wanted to go after, what their enemies list was. And I said, how is an individual district court judge to understand a search warrant, for example? Are you going to assume that it went through the usual layers of review in the Department of Justice? Or are we going to assume that Trump ordered X to do it? And should a district court presume that the regular processes were followed in the face of evidence that that is not so? And I think courts are grappling with that now.
And just for the record, I love Just Security, and Ryan is a friend. I'm totally joking. Let's talk about the elephant in the room, which is the Supreme Court. And I'm going to direct these questions in a different way to you both, or to the two of you and to Judge Luttig. The Supreme Court has this complaint about the district courts, and some of them are articulating it openly, which is that that they're not taking guidance, that they're being sort of insubordinate, and some of them are articulating it, I would say, a little bit more passive-aggressively, allowing things to go forward with 0 paragraphs of explanation, for example. And so from the district judges, I would love to get a sense of the level of frustration among your colleagues, your former colleagues, at this kind of throwing, you have the sense of throwing darts at the wall, but the wall is being moved and you're blindfolded, right? And from Judge Luttig, I'm interested in your sense of what the Supreme Court thinks it's doing here with the shadow docket, that you're providing a whole lot of interim permission for the administration to do an enormous number of things, and you're pushing off the date in which you have to explain your reasoning for that, sometimes by 2 years. What is the logic of this in your view? So I want to start with you on this, and then have our district judges talk about the effects of this behavior, for the people who actually have to administer cases.
Well, obviously, there's no logic to it at all. But there is thinking to it, and that's what we need to be concerned about. The Supreme Court knows exactly what it's doing, but let's just level set ourselves for the moment. The Supreme Court has no power at all in our system of government accept that power that comes to it by virtue of its reasoned opinions of constitutional law. Whenever the Supreme Court is acting without opinions of law at all, let alone reasoned opinions of law, it is acting illegitimately, period. It doesn't have the power of the purse. It doesn't have the power of the sword. The only power it has, and the only power that it has to wield on behalf of the American people, is the power of its persuasion. So to address this issue that Ben's talking about from the district court perspective, because any district court judge would be reticent to accuse the Supreme Court
Excuse
of
me for a
anything.
second. Could whoever's phone that is, could you please make it stop?
But, we all know who and who all has criticized the federal court, lower federal courts. But that was a horrible mistake. And he and they knew it. When they said that the lower courts weren't following their orders and judgments, what you need to understand, which you already do, is the Supreme Court wasn't issuing any orders or judgments or opinions. It was just staying the 50, 100-page opinions of the lower court without one single word of reasoning or explanation or judgment. When the Supreme Court does that, it's exercising nothing but raw power. And the Supreme Court has no raw power. If I were sitting and the Supreme Court said that about an opinion that I had written, they would have gotten an earful.
Well, I mean, judges actually gave the court the judicial equivalent of an earful. So footnote 7 or 9 in Allison Burroughs' decision on the Harvard grants case was all about, with respect, Supreme Court, we would follow your orders, but they are, how shall I say, incoherent. Those are not exactly her words, and then she said in court, she said in the body of the opinion that this is Calvin Ball, quoting Justice Jackson, only there actually are rules that I'm going to follow, and the rules that are in existence now, which is to say, it was only recently that anyone would have envisioned that the shadow docket decisions, decided as they have been, comprised precedent for anything. And Judge Burroughs was saying, how could anyone have anticipated that? I will follow the law as it is, not the law as you intuit in your decisions. And something I wrote, again, it's one of the most fun about not being a judge anymore is that I can say things like this. I wrote an article in which I said that the shadow docket has all the formality of notes on a napkin. No one followed me on that. But I think that there's a level of outrage, which interestingly enough is being reflected in the decisions. There was not only that footnote in Judge Burroughs' decision, Judge Young, who had apologized in open court, widely covered, because he was the one who had been described as defying the Supreme Court in his latest opinion, which sort of bordered on a screed, if the truth be told. He answered that, he's following the law as best he can. But I think that actually had the opposite effect to what the Supreme Court may have wanted, which is it outraged the lower court. And I think no one has paid attention to it.
Ben, the Supreme Court is in a self-inflicted crisis. think about that. How is it that the highest court in the land renders itself in constitutional crisis?
Judge Grimm?
So what I'd like to just sort of share a sense of scope here. The district judges in the United States are being overwhelmed with these cases. There have been hundreds of these cases filed. Many of my colleagues on the District of Maryland have had 4 or 5 challenges to various of these executive orders or policies or actions by the administration. It is impossible, if you don't sort of know how already busy and overwhelming it is to be a U.S. district judge. It's like drinking out of a fire hydrant every single day. And on top of that, to have these cases where, as Judge Gertner said, you are wondering whether or not the information you're being given by the proponent of the action is accurate. When you're asking for details and follow-up, you're getting gibberish. Or people who come in and say, I agree with you, Judge, but I don't know what to say, and then they get fired the next day, and there's somebody else in there who comes back and says something different. When you get slow walking of cases before them, and all the other cases that they would ordinarily have, the people who have an expectation that the district courts will do their business is being held in abeyance while they deal with these cases. And they're issuing, as Judge Luttig said, not just a 3-paragraph, 3-page decision, but sometimes 90, 100 pages and working around the clock. And the level of pressure that they're under. And then to explain, and keep in mind, most of these things have come up because of some emergency request, relief, a temporary restraining order, or an injunction, where the court has no choice except to forecast the likelihood of prevailing on the merits and to balance the equities. If we order this and we don't order it, what will happen? Who will be harmed the most? And to have this accelerated at a point where this is brought forward without the ordinary fact-finding and the trial basis and jury trials, where there's a right to a jury trial, is all being done on this expedited emergency basis on issues, as you have pointed out, that have never been brought to the district courts before. And in response, if you get a brief order that simply says it's wrong, that you didn't do it, there's no explanation, or even more, what appears to be a personal attack when these judges are doing their very best under extraordinary circumstances. Not even it would be, the district court judges could be forgiven for expecting perhaps a word of acknowledgement about the unbelievable pressure that they're facing. There's a frustration there because they're not trying to disregard precedent. But there has to be, but when you have, when it's not clear, when there is established precedent that seems to go one way, but the tone of some of these other decisions and other cases suggest that the court has, without having done the ruling that explains what it is and creates the law of the land, you can understand there's a level of frustration. And that's why you had the unprecedented event of 12 district judges recently anonymously went out and voiced their frustration. And that is unfortunate, and it's unfortunate for a number of reasons. But you all remember the famous House divided against itself cannot stand speech that Abraham Lincoln gave in 1857 when he accepted the Republican Senate nomination and launched his national political career. Of course, this is a quote that comes from the Bible. But at a time when the federal judiciary should be unified, it is very, very, very sad to see that there seems to be this frustration that is being expressed itself publicly in opinions and in public comments by the lower courts and the federal courts. This is a time when the courts need to be unified because they are the last thing standing between the founding principles that all of us believed in, and many of you in this room, I know it's the case for the 3 of us up here, have spent our entire life in the service of these principles that we believe are so important. That's the kind of dedication that we're dealing with here, and I would hope that a deep breath could be taken and some encouraging words might be able to be understood and shared. But the district courts are quite literally overwhelmed. And ordinarily the Supreme Court doesn't have the kind of emergency cases before that, the volume that they are having now, and perhaps that's a level of strain on the High Court as well. But the district courts are feeling it by an order of magnitude, and that they're doing what they're doing is really remarkable.
Yeah, for those of you who don't do or follow litigation on a day-to-day basis, the magnitude of this point is really, really important to understand. When the Supreme Court hears a case on an emergency basis, that means reading papers. And every now and then you might have an oral argument. Mostly, it's about reading papers. That's what the emergency docket is. When a district court hears a case on an emergency basis, there are hearings, there are going to be arguments, there are going to be witnesses potentially, particularly if you don't believe the things that the government is saying, you may require, as a number of courts have done, sworn documentation of factual representations. There's a fact-gathering process. The amount of work that this involves, I mean, I'm worn thin following it. We do Lawfare does a weekly roundup of all the litigation. It takes a team of people full-time just following it enough to have a coherent discussion about the week's events. Each of these cases is enormously labor-intensive for the district judges and, let's be honest, for the advocates. I'm a little bit less concerned about the Justice Department lawyers right now, but all right, let's.
I just got to put one little parochial comment in there. The typical district judge has 2 law clerks. The courts of appeal have 4, and the Supreme Court all has 4. So the typical caseload of a U.S. district judge is somewhere between 500 and 1,000 cases pending at any one time. And federal courts don't get, the easy cases. So just the level of pressure that's being put on these courts, and the fact that they haven't broken, but that they have stood firm, they have largely been, in my very biased opinion, heroic.
Ben, let me just punctuate this part of the discussion this way. So somebody important asked me to write an important article, and I've done so. And on this issue, what I ended up saying after explaining the problem, I said by the time that the Supreme Court decides these cases, if it ever decides these cases, the damage to the Constitution of the United States and to the nation will have long been done. And that damage is irreparable as of today.
I want to chime in too. You'll get your last question, Ben. Don't worry about it.
Yeah, I got 2 more, and we got to get through.
No, and I'll say lawfare 10 times.
We got life tenure up here, Ben.
Right. I mean,
I don't.
I mean, that was the other. We were going to talk about the shadow docket at one point, and when you think about it, there was a decision by, I think, Justice Kavanaugh, where he was chiding the lower courts. This was before before Justice Gorsuch dressed down a district court judge. But Kavanaugh had something about how this court is in a perfect position to deal with interim orders, which, of course, is not remotely true. Not remotely true. It's not just the cases that they're taking and overturning or overturning without explanation. But we are also working very hard. Excuse me, just going to shut off my phone here. We are also working, the district courts are also working very hard to deal with the standard for a preliminary injunction, irreparable harm on one side, likelihood of success on the merits. So the likelihood of success on the merits requires, very quick dealing with substantive issues that have never been dealt with before. But the irreparable harm part is extraordinary. Irreparable harm to the government to continuing to do that which it has been doing for hundreds of years versus to the individuals who were laid off, or the individuals who were riffed, or the individuals whose funding was terminated. And they have been over and over again finding irreparable harm on the side of the government, which is really totally changing what the standards have been.
All right, let's talk about those cases in which the district court orders something and you go up the appellate chain and nobody stops it. And there have been these cases. Judge Luttig alluded to one before involving the Alien Enemies Act. And then you suddenly have this other problem, which in my 30 years of covering the federal courts and writing about the Justice Department, I've never seen before, which is a systemic concern about the compliance of the federal government. And so, Judge Gertner, you raised this issue, so I want to direct this in the first instance to you. You know, the district judge has some tools at their disposal, but they're not robust tools compared to, say, the tools of the executive branch if it's committed to defiance. So, you know, people keep saying in a kind of hair on fire sort of way, what if they defied the federal courts? Well, they've already defied the federal courts in a number of areas, both in micro ways and in macro ways. And so it seems to me the relevant question is, what are the tools and strategies available to district courts and to appellate judges who are inclined to be supportive of the court's authorities and institutional capacities? What are the tools that are available here to bring an executive branch in an area where their legal compliance is not in question, it simply isn't happening, into a compliant posture?
I think that has been the hardest question, as you saw in the case involving deportations to third countries and deportations in violation, in the purported authority, rather, of the Alien Enemies Act. The judge, Judge Boasberg, this was here, has walked up to the edge of contempt. Walked up to the edge of contempt. And there's actually been even more information that has since come out since his ruling. He found probable cause to believe that there was contempt, a finding which had been reversed by the DC Circuit, and is, I think it is about, they've asked for en banc. But he has, every judge, even in a case of not as huge importance as these cases are, but every single judge has had to deal with, what do you do in the event of noncompliance? What do you do in the event of noncompliance? And how far do you go? I mean, I don't know that where there's much. The tool is contempt. The tool is criminal contempt requires that the Department of Justice be the one to bring the case, right? And in the event the Department of Justice doesn't bring the case, then there has to be. You can argue that you could appoint rather a special counsel, with all of the issues swirling around special counsel appointments now. So Judge Boasberg went to civil contempt, or at least it's actually ambiguous as to whether he went to civil contempt. But civil contempt is another alternative with fines, etc. Whom do you hold in contempt? I think that what you're seeing across the country is that judges are going up to that point and not quite sure where to go after that. Another tool that you've seen in some jurisdictions has been bar complaints against the Department of Justice attorneys who seem to have lied, or the proof have lied. But and then there's a question of enforcement of orders, and enforcement of orders requires the Marshal Service, which is under the Department of Justice. I don't mean to suggest that judges do not have the power to make a difference. That power right now is largely expressive. It's the power to articulate what's wrong with what the government did in a way that the public can understand. But when the government begins to disobey, and I think we're on the verge of that, if not have already passed it, there'll be an interesting collision. It's not clear what will happen.
I want to tell a happier story about compliance as stepping out of my role as moderator for a minute, because I actually think this is an area where the work of the district courts has been sufficiently strong that you can actually trace the effect. So perhaps the single most horrific case that we've dealt with so far is the one in front of Judge Boasberg, the JGG case. That case had a repeat in front of Judge Suknanan the other day, a few weeks ago. My colleague Anna Bauer, who has lately become famous for other things, wrote a really remarkable piece about this, about how clear it was that Judge Suknanan had learned from what happened in front of Judge Boasberg, how she handled the matter differently. This is no shade on Judge Boasberg. He, had no way to know that what was going to happen was going to happen. But she played it differently. And by the way, Judge Zines has played it differently. And I do think you're seeing a whole lot more judges just manage their cases in a fashion that is in real time, make the Justice Department lawyer submit an affidavit for every single fact that they're claiming, right? Make somebody individually accountable under oath for each factual representation, and that there's a real-time disciplining effect there. And by the way, you're seeing it into the criminal cases now. And so I want to say that one of the mechanisms is not actually punishing the government for defiance. It's managing cases in ways that don't permit the defiance in quite as, it's an incomplete solution. But I do think if you're watching the district courts, they're behaving differently than they were 6 months ago, and that's a really good thing. Judge Luttig.
Well, Ben, that's pitiful.
On whose part?
I'll leave that to you.
I stand rebuked.
Look, ladies and gentlemen, this isn't a symposium on district court judges. We're in real life here. We're not talking about contempt of some plaintiff or some defendant. We're talking about defiance by the President of the United States of America. Explicit, express defiance. For God's sakes, we're sitting here, wringing our hands over whether the district court judges, need to make additional findings so that the Supreme Court might uphold them, but almost certainly will not. Were they ever to find, for the first time in American history, that the President of the United States of America is in contempt of a federal court? So let's bring ourselves to talk about what's at issue. Every day of the week for the past 10 months, judges like Judge Gertner and Judge Grimm are facing the President of the United States and the Attorney General of the United States, who, as we've already talked about, lying to their face, lying to their judges, their prosecutors or lawyers are lying to the federal courts. Meanwhile, outside the courtroom, the President of the United States and the Attorney General of the United States are trashing the federal courts, trashing the individual judges, calling them every name in the book. Never in American history has this ever happened. And these people who are trying to do their job under those circumstances are looking up at the Supreme Court of the United States, who they know to a virtual certainty would reverse them in a second if they held Donald Trump in contempt?
All of which brings us to the question of the attacks on the judges and the fury that you hear in Judge Luttig's voice right now is, amply justified by Stephen Miller's appearances on television, by Donald Trump's own statements about individual district judges, starting when he was a candidate and dismissed Judge Curiel as a Mexican. Not that that would be a bad thing, but he is in fact an American citizen and a sitting federal judge. And by the way, he was responsible for supervising the Trump University case. This is different from, I used to write editorials for the Washington Post, and I used to sometimes take judges to task for rulings. And I'm not shy about criticizing federal judges. This seems to me deeply different from the normal criticism that judges have to be big boys and girls and accept. Judge Grimm, how big a problem is it?
So let me just say this. I will define the scope of the problem by pointing out to some things that have never happened before. In his year-end report on the federal judiciary, issued in December of 2024, last year, Chief Justice Roberts talked about the increase in attacks against the judicial system and individual judges. He pointed out, as all of us believe in this room, that there's a First Amendment right to criticize any government official, but he identified 4 things that go beyond the scope of what can be justified. Number 1, threats against judges. These threats are being made where district judges are having threats communicated to them. We are going to rape your daughter in front of you, cut her head off so the blood splatters on you, then rape you and kill you. Now, if that doesn't shock you, I don't know what will. There are the point where the Marshal Service has said that there are over, I think this year it's almost up to 500 credible threats against U.S. district judges. The Marshal Service does not have the staff or the resources to be able to deal with that. But that's the level of attacks that we're getting. Number 2, attempts to intimidate. Number 3, disinformation about the court system. And number 4, calls for disregarding the outcome of judgments issued by courts. Now, that's the Chief Justice of the United States talking in December of 2024 about 4 actions that are indefensible, and then look back and see whether or not all 4 of these are being present today, and the answer is yes. Now, keep in mind that when you have a cabinet secretary referred to as the United States district judge as an idiot 3 times in the course of a 2-second sound clip because they disagree with a ruling that was made, that judge can't come up and say, I want to tell you why I ruled that way. They can't. They're ethically prohibited from discussing cases pending before them or issues that might come before them. So they are unable to respond. The Canon 8 of the Code of Professional Responsibility puts on lawyers the obligation to defend the judiciary and the judicial system when it's unfairly attacked. In Pakistan, when President Musharraf, who essentially had a peaceful coup, dismissed members of the Supreme Court because they would not take an oath of allegiance to him personally. For 2 years, the lawyers in Pakistan went to the streets, and they took to the streets in protest for doing that. In Poland, the judges and the lawyers went out town to town to talk about the attempts to do that. When there was an effort in Israel to try to neuter the Supreme Court of Israel, 500,000 people went out in the streets and protested. And each lawyer who has passed the bar took an oath to defend the Constitution and support the judicial system. And while many of the people in this room are lawyers and have done courageous actions and are doing courageous actions, overwhelmingly The duty to speak out in defense of the judicial system rests with the attorneys who have a vested interest in making sure that the system operates the way that it has. And there is much room for improvement in that response. And so the way we have to keep in mind, one thing, I'll be quiet then, is you have to understand how little the average American knows about the judicial system. The overwhelming number of Americans have never had any engagement with the legal system, so they get all their information from other sources. When was the last time you saw a movie, a novel, a television show where the judge was working 7 days a week, 10 hours a day trying to get it right? Never. And so where do they get their information? Social media. I can tell you this. I've written a number of editorials in defense of the judiciary. Bloomberg and others have published it. If 1,000 people read that, it's a home run. But if I go on X and I say, if I put hemorrhoid cream under my eyes, my wrinkles will go away, 8 million people will respond to that. And so what we have to do is we have to engage with the American people so they understand the vital role that the judiciary plays and why it is so important now, because the rule of law cannot exist without the support of the public and their willingness to comply with an outcome from a court that they perhaps disagree with, but they believe in the system as having internal checks and balances that will deal with it. And until we can focus on that message, then the people who call the names dominate the public sphere. And if that happens, eventually, the public, which some people would say is borderline apathetic now, will turn. And if that happens, then all the liberties and all the freedoms and all the things that we all cherish will be in grave peril.
I promised my panelists that this agenda would take exactly an hour, and exactly an hour later, I claim victory. I want to thank all three of our panelists, but I want to give you guys an admonition first, because everything any of them ever said on this podium here was off the record, and you guys aren't journalists, so maybe you wouldn't understand, but I thought I should let you know. Thank you very much to Judge Luttig, Judge Gertner, and Judge Grimm.